They're owned by a company
Oh, they
that
are.
puts wind towers in.
Oh, I'm sorry.
Supervisor. Our time.
Board of Adjustment.
Board of Adjustment.
Pete Bushman, supervisor. Hey, Chromite, zoning. Alex Litterall, zoning administrator.
Andrew Schmidt, assessor's office. Dan will be back in a second. He's the assessor.
Okay, Carla Becker, Delaware County Auditor.
I'm Dan Fox from ECIA.
And more questions from people. So, introductions. Let's get started.
All right. Well, I think we're good to go here on the Zoom meeting recording. So we don't have anybody that's watching on Zoom yet, but we're just kind of recording this meeting in case for at least one person that would like to view it after the fact. So that's where we have the camera here, hopefully recording everything.
You're unmuted.
And we are unmuted. So I think we're good to go. All right. Well, thank you everybody for coming. Welcome to our introduction to Delaware County zoning training. So this is our second of two trainings. This is the same presentation that we did back on the 7th, but so it's our second one. So we already went around and did our introductions. We welcome everybody. And thank you, especially to those of you that have agreed to be on the Zoning Board of Adjustment or the Zoning Commission. Those are really important positions, and the county literally can't do zoning without people to fill the spaces on the boards and commissions. So thank you for doing that, and thank you for being here to learn more about the zoning ordinance. So as part of the introduction here, I guess I can introduce the agency that Laura and I both work for. We work for the East Central Intergovernmental Association, or ECIA. And so ECIA is the Regional Council of Governments. We serve a 5-county area. The cities and counties within that area are members of ECIA. And our mission is to provide a variety of services to those cities and counties. And so there's the 6 broad categories that we work in listed there. But one of those areas is planning and zoning. And so we have helped Delaware County put together the zoning ordinance that the county adopted earlier this fall. And the county has brought us back to help provide some training and technical assistance to get this zoning ordinance in administration of that ordinance up and running. So the outline for our presentation today, we're going to start off with kind of an overview. We'll talk about what is the comprehensive plan and what is the county zoning ordinance. Then we'll talk a little bit about the players in the process, including the Zoning Commission and Board of Adjustment. We'll get into the contents of the zoning ordinance a little bit. Then we'll talk about how the ordinance is administered, and then go into a little more detail on the powers and authorities of the Board of Adjustment, the Zoning Commission. And then at the end, we have a few case studies. And so hopefully those will kind of stimulate some discussion and questions. And so yeah, I think that's probably will be the most helpful part of the training is those case studies. So I guess we'll jump right into it. I guess before we do that, I will say briefly that this is a lot of information. There's a lot to cover. So, we don't expect that you're going to know everything about zoning at the end of the day today. But we are here to be a resource and provide questions. And so Alex is here also as the zoning administrator. That's part of his job too, is to help people understand and answer questions and things like that. So
Usually can ask questions whenever.
yes. Yep. And so if you have a question, feel free, stop us, and we'll go ahead and address that as they come up. All right. So first section we have here is, what is the comprehensive plan? So a comprehensive plan is a document that presents a vision for the future with long-range goals and objectives for all activities that affect the growth and development of the county. It is comprehensive because it covers a wide range of issues. So all those issues that are important for the growth and development of the county. It's a long-range planning document. So typically that's looking 20 years out into the future. It is a policy guide. It is not regulatory. And the policies that are recommended in the plan are shaped by public participation. So when a comprehensive plan is developed, there's usually a public input process that goes along with the development of that plan. So one of the most important thing that you need to know in the context of zoning is that the Iowa Code requires that zoning regulations are made in accordance with a comprehensive plan. So there's no requirement in the Iowa Code that requires a county to adopt a comprehensive plan, but it does say, if you're going to do zoning, you have to have that comprehensive plan in place, and you have to do the zoning in accordance with that plan. So the county's current comprehensive plan was adopted in 2012, and the vision statement of that plan is that Delaware County envisions a community that encourages healthy, active living, promotes economic development, and the preservation of agricultural land. So the goals and objectives of that plan focus on economic development, housing, public infrastructure and utilities, transportation, land use and zoning, and recreation. So one of the key things, one of the key parts of the comprehensive plan that's referenced a lot in zoning is the future land use map. So this we're showing up on the screen here is the future land use map from the 2012 comprehensive plan. And the purpose of this map is it kind of lays out a guideline for future development of land within the county. So as you can see, the map's a little difficult to see from this distance, but what you can tell from this distance is a lot of the map is showing is colored white. And those white areas are intended to be agricultural areas. And so as we get into talking more about the zoning ordinance and about the direction of the county, and we look at the zoning map, you also see something similar there, where the map is mostly white, agricultural land, and that's what we anticipate it being in the future. So most of the area of the county is going to be agricultural, but there are going to be areas of residential, commercial, and industrial land within the county. So those are typically concentrated in the areas around the existing cities or unincorporated communities like Petersburg or the Lake Delhi area within the county. So we will come back to discussions of the future land use map and the comprehensive plan as we get into the zoning ordinance. But I guess just know that if we come up to a question with the zoning, what should the zoning of some sort of property be? What are the, what do we want to rezone a specific property from one zoning class to another? The comprehensive plan is really there to be used as a guide for planning and zoning commission members, for board of adjustment members, for the supervisors. It's there to provide guidance and to look back at what priorities have been set by the county previously. So our next section is, what is the zoning ordinance? So sort of the textbook definition of a zoning ordinance is that it divides a community into districts or zones and regulates land use activity in each district, specifying the permitted uses of land and buildings, the intensity and density of such uses, and the bulk or size of buildings on the land. So the zoning ordinance is divided into two main parts. The first part is the zoning map that shows where all the zoning districts are, what land is designated as what district, and then there's the text. So that's the actual written regulation parts of the ordinance. So the purpose of zoning regulations as defined by the Iowa Code in chapter 335.5 is that zoning the purpose is to preserve the availability of agricultural land, to consider the protection of soil from wind and water erosion, encourage efficient urban development patterns, lessen congestion on the street and highway system, to secure safety from fire, flood, panic, and other dangers, and to protect the health and general welfare. And going on to provide adequate light and air, prevent overcrowding of land, to avoid undue concentration of population, to promote the conservation of energy resources, to promote reasonable access to solar energy, and to facilitate the adequate provision of transportation, water, sewage, schools, parks, and other requirements. So in general, what we're trying to do here with the zoning ordinance and what the purpose of the ordinance is is to really, try to do all of these things. Most importantly, I think, efficient use of land, facilitating adequate infrastructure provision in the most efficient way possible, and also protecting the health, general welfare of the population of the county are kind of some of the more important ones that are usually focused on with the zoning ordinance. But we did want to mention Iowa Code Chapter 335. This is the chapter of the Iowa Code that gives counties the authority to regulate land use through zoning. And so it also kind of establishes the rules for how counties can do that. And so there are some things where some limitations that are placed on the counties by the state, some things the county can't do through the state. And those are all contained, those regulations are all included in that chapter 335 of the state code. So this is the example of the 2022 zoning map. So this was adopted along with the actual text and the regulations in the zoning ordinance itself. As you can see, again, most of the county white area. This is the A1 agricultural zoning district, so that covers the majority of the county. And there's, again, a lot in the areas near the cities. There's where are existing unincorporated kind of development areas like the Lake Delhi area. Those are the areas where you see those other colors and other zoning districts. So this map, as you can tell, this version of the map is intended to be kind of printed out as a large wall-sized map. There will be one official zoning map that's kind of the official one, the one that you go look to as the main reference. But there are also other resources, including the county's Beacon website. Zoning districts are included on there, and it's especially if you're looking for the zoning of one specific property. It's a lot easier to look things up that way. So that's kind of considered an unofficial guide. It's not the official map, but it should be the same information on both maps. All right, so now we are on to the table of contents of the zoning ordinance. So there are 8 main sections of the ordinance. So we have general provisions. So those are kind of just sort of the general rules and guidelines for zoning. Then we get into the zoning district regulations. So each one of those zoning districts has its own set of regulations that go along with it. So those are each different sections of the ordinance. Then there is a sign regulation section that regulates the size and placement of signs. Off-street parking regulations, so how many parking spaces are required for each type of development. Then the administration and enforcement section that kind of spells out the rules and responsibilities for administering the ordinance. So kind of describes what Alex will be doing as he's administering the ordinance. Then the next 2 sections talk about the Board of Adjustment and the Zoning Commission. So establishing the powers of those 2 commissions, or those 2 boards, and kind of describing their roles and responsibilities. And then lastly, have the definitions. So this section kind of defines all of, or as a good number of the terms that are used within the zoning ordinance, and is sort of a helpful section if you're trying to interpret the meaning of certain regulations. This is a helpful section to check out. It provides kind of how some of these terms that are used in the ordinance should be defined and applied when you're interpreting. So that's the outline. And I think we are on to next section, which is the players in the zoning process. And Laura's going to take over.
Hey, thanks. Yeah.
Right. So I'm going to talk about the players in the zoning process. Did I go too fast there? There we go. I did. Yeah, Tom was up there. There we go. Okay. So the first 2 are the state legislature, which has given local governments the authority to undertake zoning. And that is that chapter 335 that Dan mentioned. And then the County Board of Supervisors have the most power and responsibility for zoning, but they may delegate non-legislative functions to administrative boards, which are the zoning commission and the board of adjustment. And the zoning commission is appointed by the board. Everyone on the commission needs to live within the county, but not inside the corporate limits of any city. The commission reviews proposed amendments to the zoning ordinance or to the zoning map. We often call those rezonings, and then makes a recommendation to the Board of Supervisors for final decision. They also may recommend adoption or amendment of a comprehensive plan to the Board of Supervisors. Thing to remember is the Board of Supervisors cannot hold its public hearing on a rezoning or an amendment to the zoning ordinance until it's received the final report of the zoning commission. And we're going to go into more detail about that process. For the Board of Adjustment, also appointed by the Board of Supervisors, also needs to be people who reside in the county but outside corporate limits of a city. The purpose of the Board of Adjustment is to alleviate cases of hardship that are created by if you were to take the ordinance literally, it is impossible for us to write an ordinance that's going to work for every single parcel or every single development that is currently or may in the future be in the county. So we have the Board of Adjustment for those adjustments. This is also a way for someone who disagrees with how the zoning administrator has interpreted the ordinance to have a chance to air their concerns, make an appeal before the Board of Adjustment. So the three things that the Board of Adjustment reviews are the appeals, and then variances and special exceptions. And we're going to talk about those in more detail. The Board of Adjustment is different than the Zoning Commission. The Board of Adjustment is quasi-judicial. Its decisions are final. The Zoning Commission's decisions are recommendations that go on to the Board of Supervisors for their own hearing and a final decision. If you have a disagreement with a decision by the Board of Adjustment, then you take that as an appeal to district court to file that within 30 days. And then there's the zoning administrator. This position supports the Board of Supervisors, the Zoning Commission, and the Board of Adjustment, and everything related to what's going on within the zoning ordinance. The administrator prepares reports on the applications that go to the Board of Adjustment and the Zoning Commission. Also has the ability to review and approve permits, issue certificates of compliance. Also is going to work on drafting amendments to the ordinance if those are brought up by the commission, the board, the supervisors, or a member of the public. In addition, the zoning administrator is in charge of enforcing the ordinance and also provides information and applications to the public. And we're going to go into those duties a little more as we move through this presentation. So I'm going to give it back to Dan now to go over those general provisions.
All right, so we're going to start getting into the content of the zoning ordinance. And so the first section is the general provisions section. So this is really the beginning of the ordinance, just sort of the general rules and regulations that are included up front. So one of the first sections under general provisions is the purpose. And this is essentially saying that all new uses, all new development must comply with the zoning ordinance as of January 1st, 2023. So that is the effective date of the ordinance. So that is after that point, any new uses or new development are going to need to be in compliance with this ordinance. Relationship to the comprehensive plan. So as I mentioned before, this is just stating that zoning decisions should conform to and implement the 2012 County Comprehensive Plan. So minimum requirements interpretation. So development and land uses should follow the zoning ordinance unless there is a more restrictive county ordinance or state law. So this is essentially saying that, kind of the zoning setting the minimum requirement, but there may be other more restrictive ordinances that are out there that an applicant or a resident of the county should be aware of. This is it. There's the next section is that it is not a licensing ordinance. So just because you have approval of a zoning permit does not mean that there's other required county or state permits are also approved. So this is just kind of giving people a heads up that there may be other requirements and regulations to comply with, and not just the zoning ordinance. So moving on, the Iowa Open Meetings Law. This is just a reminder that all zoning commission and board of adjustment meetings are subject to the Open Meetings Law if there is a quorum of those groups present. Then moving on to the official zoning map. So like I said before, there's an official zoning map that's located in the office of the zoning administrator, and it can be changed only by the board of supervisors. So if there is a change that's needed to that map, it needs to go through the map amendment process, and the board of supervisors have the final say on any changes to that map. So the next piece here is kind of one of the critical parts of zoning for counties in the state of Iowa. So this is the agricultural exemption. So by Iowa code, farmland and farm buildings are exempt from county zoning, but not from county floodplain regulations. So as I mentioned before, the state code sets the rules for zoning and what counties can and can't do within the state. And one of the rules that's included in the state code says that farms and farm buildings are exempt from county zoning regulation. This can get to be a little bit tricky, and we'll probably get into this later on. But just because a property is zoned A1 agricultural does not mean that it meets the requirements for being, or meets the definition of farmland or farm building. So there is a difference between agricultural zoning and being classified as a farm. And so we'll get into that a little more later, but that's just remember that for now, that there is that difference in place. Voluntary compliance is the policy in Delaware County. So even though farms and farm buildings are exempted from regulation, and the county can enforce zoning regulations for those types of uses, the county does request that those farm property owners voluntarily comply with the regulations within the zoning ordinance. So this comes in especially with things like setbacks from the roadways, things that could impact public safety, but then also floodplain regulations. So the county can enforce floodplain regulations. And so I think if there's a farmer that wants to put up a new building, it may be helpful to them to come in and say, hey, I'm putting up this new building. Am I in the floodplain? So I think that can prevent issues later on down the line. So farms under 5 acres must demonstrate that the property is used for agricultural purposes by providing a site plan to the zoning administrator. So when we were putting together the zoning ordinance and doing some research, and we work with the board of supervisors here in Delaware County to try to come up with sort of a cutoff point where we thought, anything over 5 acres is probably being used for agricultural purposes and probably qualifies for an agricultural assessment. But anything that's under that, we may want to take a little bit of closer look at and make sure that it is being used for agricultural purposes and not just for just strictly residential use or commercial use or something like that. So that is set the cutoff at 5 acres. So for the most part, anything over that we're not going to worry too much about. And for anything under 5 acres, we're just going to ask that the property owners submit a site plan and demonstrate that they are actually using that for farm purposes. All right, so the next section of the general provisions section of the ordinance establishes the zoning districts. So The districts included in the zoning ordinance are A1 agricultural, R1 single family residential district, R2 multiple family residential district, R3 mobile home park district, and R4 Lake Delhi residential and recreational district. We also have a couple of commercial districts, so mixed use commercial district, C2 general commercial district, and then 2 industrial districts. So the I1 light industrial and I2 heavy industrial districts. So as I mentioned before, that most of the land area within the county is going to be covered by the A1 agricultural district. And then we have that group of different types of residential districts, and then commercial districts and light and heavy industrial district. All right, so the next section is the district regulations, and so I'll turn it back over to Laura.
So I'll start with the purpose and intent of each of those zoning districts. The A1 agricultural district is those areas that are appropriate for agricultural and agricultural related uses. And it's intended to be a reservation of those areas that are suitable for non-agricultural use until the land is actually needed for development in accordance with the comprehensive plan. The R1 single family residential district is intended for that low density single family residential use. It's generally limited to already developed areas, but it may be expanded to include new development for more single family housing. The R2 multifamily residential district is intended to have a little higher density with 2 family and multifamily residential development. It's again limited generally to already developed areas, but it could be expanded to include appropriate new development for multifamily or even single family or 2 family housing. The R3 mobile home park district is specific for mobile homes that are used for dwelling purposes. They're to be placed only in mobile home parks, except for some other sections of the ordinance where they can be placed. They're generally pretty restricted, however. And a mobile home park can be established only in this R3 district. So it's a very specific, specialized district. We also have a very specific and specialized district for the Lake Delhi area. The R4 residential and recreational district is to acknowledge that those are the principal uses that are going on in the Lake Delhi area, and to have regulations that work with that development in terms of where they're placed and where they're developed. And this can include the temporary, seasonal, and permanent residential dwellings, as well as the public open space and commercial recreational uses that are within that recreational facility. There are also other rules that apply to this district, and so we've mentioned those in the definition. Again, this kind of a heads up that there are other things going on in conjunction with the zoning regulations. And there's also state Department of Natural Resource regulations that can impact this district. So a lot going on in this district, but we wanted to create something that would cater to the development and projected development in this area.
Is there, like for instance, in our Lake Delhi area, there's quite a few mobile homes. So if it's not in an actual mobile home park, would it be R4? If it's in a mobile home park, would it in the R4 district, would it be R3 or would it still be R4?
I'd have to look up the list of permitted uses in R4, but we may allow it because it allows temporary and seasonal dwellings, which mobile homes, campers, RV would be part of. Do you happen to have that handy?
Yes, I do.
So that's maybe one where they can also be here, maybe because they're already there.
What I'm thinking of is down there. Yeah, well, no, I'm thinking of the one that's just creating. Yeah, and those are more permanent campers, they don't move, people reside there.
Camping trailers, mobile homes, they're included in there as well.
So they would be R4 versus an R3.
They don't have to be rezoned to R3, just this district is one of the, it's maybe the only two, I'm thinking. Oh, the other place a mobile home can be located is in the A1 agricultural district as a secondary dwelling for a farm. So there are some specific regulations for those, but we also wanted to be able to have the opportunity if someone wants to have a mobile home park develop, if that's what they wish to do, then we have regulations to help them with that.
When you say secondary dwelling to a farm unit, is it
That assumes there's
singular?
it assumes there's a farmhouse there.
Yeah, and that's singular or plural? Can I have multiple mobile homes on the adjoining parcel?
Yeah, I don't think we have a limit on the number of homes in the A1 district for a farm.
That's not one that kind of.
And then, of course, if it is a farm, you're not regulating it by zoning anyway. But we have regulations in this ordinance because, as Dan mentioned, we're looking at voluntary compliance, and so you want to have some guidelines for folks.
So the rule on that is that it's one mobile home,
it is one.
or manufactured home per farmstead.
Oh, it is. Okay, thanks. Okay. I'm working with, just getting done working with Jackson County, so sometimes I may be quoting their regulations. So I think I will defer all the questions to Alex as he's got that ordinance, and I have two in my head and they're mixed up. We also have two zones for commercial development. The C1 mixed commercial district is to accommodate uses that could be found in what would be unincorporated communities that have they may have some commercial structures and as well as residential. And so this is maybe an area of a little higher density of use, a little more mixed use. And so our intention was to provide some accommodation for those existing types of development. The C2 general commercial district is really to address probably, I would say, more recent variety of commercial uses. These would be ones probably located along highways or major roads that would cater to people traveling, or commercial areas that provide services to residents of the county or businesses in the county. And then there are two kinds of industrial districts. The I1 light industrial is intended to be for a variety of industrial warehousing units, generally where things are kept inside buildings, and we use that enclosed storage or enclosed operations to minimize any adverse effects on adjoining properties. There could also be a need for heavier industry. So the I2 heavy industrial district provides for the opportunity to have areas develop for the operation of industrial distribution manufacturing uses, which tend to be more intense and not always as compatible with surrounding types of land uses. So that was the purpose and intent. And I want to talk, we're now going to have Dan go over what are the common elements of the zoning district regulation.
Yeah, so as I think I mentioned before, each zoning district has its own set of regulations for uses and bulk regulations for within that district. We won't have time today to go through each one of those districts and look through all of those different regulations. So what we have here in the next few slides are some discussion of sort of the common elements. So while each one has their own district regulations, each zoning district section is kind of arranged in the same way. So the common elements of those zoning district regulations include, so there'll be a section for permitted principal uses and structures, bulk regulations, permitted accessory uses and structures, special exception uses and structures, special requirements, which vary by district. And then there's a section for sign regulations, which just is a reference to the sign regulation section of the ordinance. And then the same thing for off-street parking regulations. It's just a reference to another section of the ordinance. So we will go through each of these in a little bit more detail here. Types of uses and structures. So principal permitted uses and structures. So these are allowed by right, and if the use meets the ordinance, if the use meets the ordinance standards for approval. So this is kind of the main primary principal use on the property. Accessory uses and structures are uses that are customarily subordinate and incidental to the principal use on the lot. So I don't know if you can see that little illustration there, but in this case, this is like a residential. So this is a residential lot. The primary structure is the house here. An accessory structure would be a small shed in the backyard. So things like sheds, gazebos, that sort of thing. Those would be kind of typical accessory structures in a residential area. And then we have special uses and structures. So these are uses or structures that may cause some additional impacts, and so they require special approval from the Zoning Board of Adjustment. So these things are allowed, but you have to go through an additional process and through a public hearing with the Zoning Board of Adjustment to get those things approved. So bulk regulations within the zoning district regulations. So these are the physical requirements for uses and structures within the district. So these include the minimum lot area and width, minimum front, rear, and side yard setbacks, and maximum height. So we have a couple illustrations on the slide here. So these are showing kind of showing an illustration of how these different regulations look. So the one here, this is just showing the lot line. So you have front yard or front lot line, side and rear. The other illustration here is showing the lot width and depth. So that's just measuring the measurements of the lot in general. And then the other illustration is showing the side yard or the yards and yard setbacks. So you have a front yard setback, side yard setbacks on either side of the property, and then a rear yard setback. So what a setback is generally, what a setback regulation looks like is just a minimum number of feet that a building would need to be constructed from the property line, or in case of the front yard, the right-of-way line. So if in the front yard, we're measuring from either the actual property line, if the roadway is like owned by the county, or from the right-of-way line if it's an easement situation on the roadway. Okay, so an example here of principal and accessory uses and structures from the R1 district. So as we said with R1, this is primarily a residential kind of neighborhood type of zoning district. So the main principal use is going to be single family dwelling in most cases for this zoning district. So that's listed down here, number 11. But as you can see, there's 10 other types of principal uses and structures that can be located within this district. And these tend to be types of uses that are generally compatible with a residential neighborhood. So things like schools, churches, and even cemeteries, golf courses, those sort of things can be compatible with a residential area. On the accessory side, like I mentioned before, garages, swimming pools, tennis courts, these are all things that are subordinate and incidental to a primary use. Typically the primary use being a residential home. So these are things that typically go along with that. And in both cases, these things are permitted within the zoning district. And so if somebody comes in to Alex's office and requests a zoning permit, he as the zoning administrator can approve those permits. There's no additional approval required beyond that. So the next section here, these are the special exception uses and structures. So kind of as we mentioned before, these are the types of uses that can be allowed in certain circumstances, but they require an additional level of approval. So number one, a daycare center, nursery or preschool. So I think that, and we also have licensed adult daycare services too. So, these are types of uses that can fit within a residential setting in the R1 district, but there may be additional impacts with vehicle traffic or noise or, that may be generated by this type of use. So these types of uses need to be approved through a permitting process and through the Board of Adjustment. So if somebody comes in and requests this, so Alex will look at when the next zoning Board of Adjustment meeting is, and it'll be on there for setting a public hearing and going through the approval process with the board. The other type of special exception permit that we have is a modification to the quantitative requirements for bulk regulations, signs, and off-street parking. So this is a way that we've structured the zoning ordinance to build in some additional flexibility with some of these bulk regulation requirements. So there are limitations set on what types of special exceptions can be granted in these instances. So for example, the first one here, line A, is no more than 50% of the requirements could be provided. So for example, if there's a 20-foot setback, it could be reduced down to 10 feet through a special exception. These exceptions also would need to have approval from the county engineer, making sure that there's no safety or engineering issues that would be caused by granting the special exception, and also the county sanitarian. So needing to determine that there's adequate space for septic and well to be located on the property without causing any health and safety issues. All right. And so this table here is showing sort of the typical table for zoning district bulk regulations. So again, this is the R1 district. And so in the first column here, we have the minimum lot area and width requirements. So for dwellings, the minimum area is 12,000 square feet and a minimum width of 80 feet for the lot. But in areas where the lot is not served by a public sanitary sewer system, the minimum lot area should not be less than 1 acre per unit, excluding the road right of way. And the lot width shall not be less than 125 feet. So, the first section here this is mainly for any properties that would be connected up to some sort of public sewer system. If that's not available, then, you need the bigger lot size to accommodate well and septic systems. So again, here we have minimum, in this column, we have minimum required front, side, and rear yard setbacks. So for residential uses, dwellings and non-other institutional uses, there's a set of setbacks here. So in the front, it's 35 feet, rear is 30 feet, side is 10 feet, and street side corner lot is 30 feet. So for the other permitted uses in the district, like schools, places of assembly, or other public or institutional buildings, there's a little bit larger setbacks required. So front 50 feet, rear 40 feet, side yard 30 feet, and street side corner lot is also 40 feet. Then below that, there's accessory structures. So this is a little bit reduced setback. So accessory structures shall not be erected in any required front yard. If attached, they must comply with all front, side, and rear yard requirements. But if they're detached, they may be erected within 5 feet of any. They may be erected within 5 feet of any principal buildings or any lot line. So if you're building a shed, you can build that within 5 feet of the principal buildings or the lot line. And then we also have a maximum height requirement. So 2.5 stories or 35 feet is the requirement for the R1 district. All right, so I'll turn it over to Laura for supplemental regulations.
So the second section that deals with the zoning district regulations. We talked about the specific regulations, the uses and the development regulations for each of those districts. This section, supplemental, provides regulations that apply to all of them uniformly. So all the uses and all the structures and all the districts are also going to be governed by these supplemental regulations. This is a place, though, where you'll find some exceptions. So exempted from regulations are typically our utility uses and structures. There also can be some height regulation exceptions for agriculture, utility, public uses, and structures. This is also the section that deals with visibility at intersections. We use what's called a visibility triangle to help people understand what that area should be. For Delaware County, the idea is that there is nothing between 2 feet and 10 feet from the ground within a 25-foot visibility triangle, so people can see around the corner, they can see a safe distance before pulling out into traffic. Other supplemental regulations include the use of public right-of-way. There shouldn't be anything in the public right-of-way except for a mailbox. It also talks to utility installation, provides for when the county will and won't pay for utility installation during county road construction or reconstruction projects. It also provides for adding a use to the ordinance by referring that to the zoning commission for a recommendation to the Board of Supervisors. All structures are to have access. We don't want buildings landlocked either to access to either a public or a private street, so that they are able to travel about, services are able to be brought to them, fire protection is able to serve them, and there's parking. Mobile homes or trailers are limited to restricted locations, and this reiterates what those are. Another important section is nonconformities. When the ordinance goes into effect on January 1st, 2023, there will be uses and structures that may not conform. So they're grandfathered under this ordinance. They're allowed to continue so people can maintain them, they can repair them, they can use them. And this can apply to not just uses or buildings, but also the lots themselves. The lot may not be an acre somebody lives on, that is not connected to a community sanitary system. Their lot size is grandfathered in. The next section is sign regulations. Each of the districts refers to this section where we put all the regulations. So these apply in all districts within the specifications in for each district that may be that are listed. And then this also provides for some exempted signs. So small signs under square foot, flags, insignia, and then government signs and traffic signs are not part of these regulations. Generally, these regulations are for an approved sign, permit to be issued by the zoning administrator, and then that the sign is maintained, it's maintained in compliance, and it does not obstruct the view of traffic for signs or a driver's view. So these are then listed and they're in 2 categories. The agricultural and residential districts have a set of sign regulations, and commercial industrial have a set. We do the same thing with off-street parking regulations. Each of the zoning districts references us to look in section 4 for those. And here they apply in all the districts. They have specific limitations on front yard parking for the residential, the commercial, and industrial districts. And then they also have minimum requirements for the principal uses and structures in all the districts. For the C1 mixed use district, which was those unincorporated communities, there's a 50% reduction because many of those buildings were built when the automobile was not the major form of transportation. So some of the things we'll look at as we try to determine what the parking regulations should be is we'll look at the total floor area, We may look at the number of employees on the maximum shift, number of seats, number of beds, number of dwelling units. So this is really teeny and hard to read. It's not meant for you to actually read. It's meant for you to get an idea of one of the tools that the zoning administrator will use. Alex has one of these uses. He can come to this chart and he can see that a daycare center, nursery, preschool, or adult day services, we're going to need to find room for 2 spaces plus 1 space for each employee on the maximum shift. If he goes through this list and doesn't find that use listed, there's one way down at the bottom that says that he has the ability to determine what would be a reasonable parking requirement for that use. So we've built in some flexibility here too. Yes.
I just have a question, and I should have asked it a minute ago about signs.
Okay.
If there's a sign on private property, but it's on a state highway or next to a state highway, does the state have the authority to set regs on that, or does the county, because it's next to state right of way?
That's a good question. I think for certain signs, billboards come to mind, off-premise signs. The state Department of Transportation does have regulations for those.
But along like the Highway 20 corridor, I think they would have some regulations. So I think this would probably be a case of one of those instances where, the counties has its zoning requirements and the state has its requirements. So you might need to check both.
Yeah.
Especially along state or US highways.
And if it's on their right of way, for sure, they'd have something to say about it. That's a good question. I would agree with Dan. We'd need to look at the specific sign and its location, and because there are lots of other things going on besides just the zoning. Okay, you're welcome. Before we get into zoning administration and enforcement, did anyone have any questions about the districts or anything else we've talked about? And if you don't have now, we can take them later. Okay, turn over to you.
We want to take a short pause just for people to use the restroom.
Stand up
and move around a little bit. I think we're at kind of a stopping point to do that.
Okay, great, thanks. There's not as much overlap as it has been in the 2 counties. It's really interesting how different they are.
If you really go out, right there.
One of the things that the zoning commission from doing, finding that or things were
Well, they should. Give it a little bit more.
Yeah, there's, we see a lot of areas, a lot of. Special exception for us, variance, sometimes that.
But they didn't have anything standing on that.
Maybe how they can develop.
But the whole thing.
So we have to say so like that is
Usually five.
built in such a way.
Because this is.
Yeah, it's not very specific. We're at 20 years ago.
And things have changed, it's not just for COVID, right? There's impacts on the whole counties. Healthcare, regional, local economics.
I mean, there's some,
Housing,
but they got a dog in the country.
That are much more.
But I thought maybe the project might be the school thing that actually.
A lot of things happen, that happen in rural areas.
You want me to get you a couple of printouts of the things?
Some of it is. It went to really affect your company. That is. Cities.
Yeah, so the idea is that where you're having something.
Yeah.
And something other than that, agricultural, you know, so a lot of them, some it's just how they should be there.
Yeah.
Water and sewer systems. Lots of things, smaller, lots compact.
It's my You won't see many, but I know the last week. If anybody wants to water.
Yes.
They can get our.
There were 50 cents for water and $1 pop, like something pop.
Yeah, yeah. Oh, and we got through a lot in the first hour, slide 45, 79, so.
Yeah. So I think we're on track.
I was on this way. Thought about it, but actually, I think we better put it on the phone.
Yeah. Thanks for that.
like it might be. Didn't have strep yet, but.
Actually, state law.
You got everything on record?
Yeah. The first time.
Right, well, I think we might start back up here. All right, so our last section, we kind of focused on the actual regulation portions of the zoning ordinance. And so now in this section, we will be getting into how those regulations are administered and enforced. So for zoning administration, so zoning permits are going to be the basic approval for permitted uses that meet the ordinance requirements. So as I mentioned before, if there's a use and it's listed as a permitted use, and somebody comes in for an application for a permit, that's going to be able, and it's listed under permitted uses, it meets all the other requirements. That's going to be a permit that can be approved by the zoning administrator. So there's no, need to go to another meeting or anything like that. That can just be approved by the right there in the office. So a zoning permit is required before construction of a new structure or an addition to an existing structure can be done, or changing from one permitted use to another permitted use. So those would both require a zoning permit. So the next type of permit that can be issued by the zoning administrator is the certificate of occupancy. So this certificate is required before a land or a structure is occupied or used. The certificate is granted after an inspection is done, and the purpose is to ensure compliance with the original zoning permit. So zoning permit you apply for and receive before you start construction. The certificate of occupancy you receive after. And so then you can, after that, you can occupy the new building or structure, whatever it is. So there are fees, and those are established by a resolution of the zoning, or by the Board of Supervisors. And so I think Alex mentioned that the supervisor would be approving those soon. And so the idea of the fees is just there to cover the administrative cost of issuing the permits and going through the rest of the administrative process. So the typical zoning permit process is going to start when the zoning permit application and fee are submitted to the zoning administrator's office. The zoning administrator will then review the application and do that with other county departments as needed. So the county engineer or other departments that are needed in that process. So the zoning administrator will then approve or conditionally approve or deny the permit within 10 days. So there is a timeline on when the administrator needs to act on the application after the permit and the fee are both submitted. So assuming there's a complete permit and fee all submitted, that's kind of when the clock starts on that 10 days. So then if it's approved, then construction work must begin and be completed within 1 year. The zoning administrator does have the authority to renew a zoning permit for up to a year after that. So if you don't get it completed within a year, they can apply for an extension. And the certificate certificate of compliance or certificate of occupancy is then issued within 10 days of the final inspection. So once that construction is complete, they'll come back to the zoning office and say, hey, we're done, come out, and ask Alex to come out and do that inspection. So he'll come out, make sure that everything is good and in compliance with that original zoning permit. And then he will issue that certificate after that inspection. So zoning enforcement. So these are the procedures that give the county a way to prevent and stop violations of the zoning ordinance. So some situations where zoning enforcement may be needed, maybe an ordinance provision is being violated. So for example, a prohibited structure is constructed or built. Another situation could be the applicant fails to obtain zoning or sign permits. Property owner could make changes that are not authorized by a zoning permit, or a property owner violates the conditions attached to an approved rezoning, variance, or special exception. So the ordinance includes language that provides the authority for zoning enforcement and remedies available to correct zoning violations. So the typical zoning enforcement procedure, it kind of starts out, it starts out less intense and kind of works its way up as you go, as we go through. And if you can't get compliance, it kind of moves up to the next level of enforcement in that procedure. So the first starts out with an investigation of a complaint. So most of the time, zoning enforcement action is complaint driven. So if somebody submits a complaint to the zoning office or zoning administrator, he will go out, investigate the complaint. So the first step is to, for the zoning administrator to make informal contact to seek compliance. So that he may just call up the property owner and notify them that they are in violation of the zoning ordinance and tell them that they need to comply with the ordinance. If that doesn't work, then it moves up to the next level, which is the notice of violation. So this is a more formal contact, would be usually in the form of an official letter from the zoning administrator, pointing out that they are in violation of the ordinance and need to correct the issue. From there, if it's not corrected, the administrator will evaluate administrative and civil remedies. You may revoke a permit or issue a stop work order. The next step would be an abatement hearing with the property owner. If that doesn't work, then there could be a civil infraction issued, and then following that, a court appearance or a court order. So if none of these enforcement strategies work, it will ultimately end up in the courts, and then it will move on to the courts handling the situation of enforcement.
I assume the county attorney would represent the zoning administrator.
Yes, I believe that's how it would work. All right, so the next section here on the administration is the Board of Adjustment. Turn that over to Laura.
Yes, that's a good question. The county attorney is going to be your best friend during enforcement actions because you're both working together to make sure that you're doing the best for the county and complying with the terms of the ordinance. But there may also be other things that the county attorney may be aware of that you may not. And also they're familiar with the court system. So great question. Thank you. Okay, so the Board of Adjustment. We talked a little bit about this. We're going to talk a little bit more, give you a little more detail. So one of the things we mentioned was the Board of Adjustment hears appeals of the administrator's interpretation. And this can be any decision made by the zoning administrator. And this is an opportunity, as I mentioned, for someone to have a chance to have their say and argue their point. The other thing we talked about, Dan mentioned there are special exception uses and structures that are listed for each of the zoning districts. These require that this use have additional review because it may not fit all on its own. It's not something that the county was comfortable with having the administrator review. And so the Board of Adjustment is looking at it because it has some unique characteristics, like a daycare with drop off and pickup, or because of its proposed location. It's a little bit closer to a property line because of the topography or some aspect of the property that's unique. There's a practical difficulty with complying exactly with the regulations. The last one is to grant variances. These can be applied to the height, to the area, the lot size, or the size of the structure itself, or the size of those yards, the setbacks and open spaces, where due to conditions at the property that aren't the result of the applicant, there becomes an unnecessary and undue hardship if we enforce the zoning ordinance literally to the letter. So those are the three powers that the Board of Adjustment has: decide administrative appeals, grant special exceptions, and grant variances. So the typical process is that an application is filed with the administrator, notices are published in local newspapers, they are mailed to the owners of property within 500 feet of the subject property, letting people know there is a meeting of the Board of Adjustment and there will be a hearing on this case. The board then holds that hearing, makes a decision to approve or deny the application, and then the board files a record of that decision, and those records are held by the zoning administrator, but they're also sent to the applicant. For special exceptions, the Board of Supervisors adopted a set of standards of approval for board members to use when you're looking at special exceptions. So there's 4 things they want you to consider: compatibility, transition, traffic, and environmental protection. Is the proposal compatible with the character of the zoning district and the immediate surroundings? Is it going to interfere with any of the use and enjoyment of adjacent properties? Is there a transition from the special exception to other uses around it? If not, is a buffer needed? What about traffic? Does it have appropriate ways to get in and out of the property for both pedestrians and vehicles, so for their safety and convenience? What's its impact on traffic flow in the area? And can emergency responders get there? And then the 4th one is environmental protection. Is this going to be a use or a structure that's operated and it's planned so that it safeguards the environment, it does not generate excessive noise or vibration, dust, smoke, all sorts of things that might impact neighboring properties or cause any kind of pollution to groundwater or have other types of hazardous and nuisance conditions. For variances, there's a separate set of standards for approval. And these are: special conditions and circumstances exist that are peculiar to the land, the structure, or the building involved. If we literally enforce the ordinance, it would deprive the applicant of rights commonly enjoyed by other properties in that same zoning district. Those special conditions and circumstances are not because the applicant caused them. The applicant won't get any special privilege that is denied by the zoning ordinance to other properties, structures, or buildings in the same zoning district. And if granted, the variance would be in harmony with the general purpose and intent of that district, and it will not end the ordinance, and it will not impact negatively the neighborhood or the public welfare. Variances, board members, should be granted sparingly. Iowa Code 33515 says you can grant them when they're not going to be contrary to the public interest. Because of special conditions, the literal enforcement will result in unnecessary hardship, and the spirit of the ordinance will be observed and substantial justice done. Iowa has adopted the following test for determining unnecessary hardship. It has 3 parts. The first is the land in question cannot yield a reasonable return if it's used only for a purpose allowed in the zoning district. Second, the plight of the owner is due to unique circumstances, not the general conditions in the neighborhood. And 3, it will not alter the essential character of the locality. The key problem with this 3-part test is that very few of your cases can meet that first part of the test, an inability to make any reasonable use of the land or failure of the land as zoned to produce a reasonable return. Why? Because typically somebody's already using it for something. So we are trying very hard to create opportunities for flexibility so that things can go to the zoning administrator. And if failing that, they come as a special exception because you don't need to prove the hardship test. So those are kind of our goals as fellow zoning administrators. We like to get people in and out so they can get off and do their project. If we can't, a special exception is the way to go because it doesn't have this really hard test. Sometimes that's not possible. And then this is what you'll use. You'll use your ordinance language, and then we'll also look at the state law. Okay, now for something completely different, the zoning commission. So the zoning commission's powers are more of, they're not quasi-judicial, so they're making recommendations. So they would, if they had been in place, they would have recommended the comprehensive plan you have, but they also may recommend amendments or modifications of the adopted plan. And as you're making decisions, zoning commissioners, you may find that something in the plan maybe has already been done or accomplished, or maybe it doesn't apply to how things are in rural Delaware County now. Maybe there should be amendments. You also have the opportunity to consider amendments to the text of the zoning ordinance. And your most frequent case is going to be proposed amendments to the map. We call these rezonings. Someone wants to change their property from, maybe it's A1 agricultural, they want to be C2 commercial. And so that's probably going to be your most frequent case. In addition, under Iowa Code, the Zoning Commission has the ability to contract with professional consultants, economic development authorities, regional planning commissions, the federal government for local planning assistance, if the Board of Supervisors has approved that contract. The typical procedure for the Zoning Commission has a few more steps than the Board of Adjustment. Again, the application is filed with Alex. Notices are published in the local papers. They're mailed to property owners within 500 feet, letting people know when the commission is going to meet. The commission holds a meeting, takes a public input, and makes a recommendation to the Board of Supervisors. And that starts their process. The board then sets a date for their hearing. They also have notices to publish in the paper. They hold their public hearing, and then they vote on the application. Did anyone have any questions on what we covered for the commissioner board? Okay, I'm going to turn it over to Dan.
Okay, so with the zoning commission, the commission can make recommendations on amendments to the comprehensive plan. So if the commission is seeing zoning cases or issues, and the comprehensive plan is making their job a little more difficult, they can make a recommendation to the Board of Supervisors to update or amend the comprehensive plan. Or if the comprehensive plan, if the county has decided that it needs to go through an update of its comprehensive plan, the zoning commission would be kind of the primary group that would be working with, that could be working with the who's ever doing the comprehensive plan update, so a consultant or someone else. So they could be advise or provide their advice and input throughout that process. And they would also make a recommendation at the end of that process whether or not the county board of supervisors should adopt the comprehensive plan.
The last time we did that,
Yep, 2012.
is that typical to see them that old, or are they updated on every 6 to 10 years or 5 years?
Yeah, I would say, I think the standard sort of recommendation would be to take a look at it after about 5 years, but 10 years is, that's not, I think you would find a lot of counties that have 10-year-old comprehensive plans, or, even older than that. I think the important thing with the current comprehensive plan is that the basic legal requirement is met. The county has an adopted comprehensive plan. And so, that requirement's there. It would just be a question of whether or not the current contents of the comprehensive plan are, still meet the needs of what the county currently has. So some standards of review for the comprehensive plan amendments. So the commission would look at whether or not the current comprehensive provisions are valid. So like we said, are they still meeting the needs of the county? Is there a need for modifications for the purpose requested, and whether or not the proposed amendment is consistent with the comprehensive plan? So, we're talking about the comprehensive plan, and we're talking about consistency with the comprehensive plan, but we may be looking at something where there's a proposed change to the future land use map. And so, is that change consistent with the overall goals and objectives of the comprehensive plan, is where this situation may come up, of whether we're checking for consistency between the plan and also amending the plan at the same time. So for zoning ordinance amendments, again, this is an area where the commission would be advising the Board of Supervisors and providing a recommendation. So the standards of review here would be whether or not the current zoning regulations are valid, whether there is a need for modifications for the purpose requested, and whether the proposed amendment is consistent with the comprehensive plan. So in all these cases, the zoning commission is going to be providing a recommendation that will ultimately go to the Board of Supervisors for approval. So again, another instance here, rezonings. So the zoning map amendments. So these are changes to the zoning map. So the standards of review here. So whether or not the district, the current classification is valid, whether there is a need for additional land zone for the purpose requested, and whether the proposed change is consistent with the comprehensive plan, considering the following factors. So whether it would result in population density or development, which would cause demand for services and utilities in excess of the planned capacity. Whether it would result in traffic generation in excess of the capacity, and whether the applicant intends to develop the property to be rezoned diligently within a reasonable time. So with any rezoning request, the big picture would need to be considered. So each zoning district has many uses, and that is what the zoning commission and the Board of Supervisors should consider. So, the important thing to consider here is that the rezoning of the property continues on, runs with the property and not necessarily with the property owner or with the specific use they're proposing today. So the best example of this is within like the C2 commercial district. There's a really wide range of commercial uses that are allowed within that district. And so when you're rezoning a property to C2 commercial, you're allowing all of those uses on that property and not necessarily just the use that's being proposed. So if the property owner is looking to establish a grocery store on the property, you shouldn't just consider the impacts of the grocery store, but also the potential impacts of all the other uses that could be allowed within that zoning district. So again, making sure that big picture is considered as part of that recommendation to the board. All right, so the next section we have here is the zoning, under zoning administration is the definitions. So for the purpose of the zoning ordinance, there are certain terms and words that are defined within the definition section. So all other terms, if they're not included in the definitions, including the types of permitted uses, shall have their normal, most common meaning. And words used in the present, and so this is more legal, kind of legal language of how these definitions should be interpreted. But words in the present tense shall include the future and singular, and the singular number shall include the plural, and the plural singular, and the word shall is mandatory and not directory. So in most cases, you'll just read the definition and be able to determine what it means from there. But in this is that section there is providing more guidance for how to interpret some of the language there. So in general, when in doubt, refer to the definition. So I think this is really intended to be a helpful guide for anybody that's looking at interpreting the zoning ordinance. So, the board and commission members, the board of supervisors, an applicant that's coming in to request a zoning permit. This is a really helpful section, to be able to define things and make sure we're talking about things using the same language. All right, so I think that is it for the zoning administration section. And so our next section is going to be case studies. And so Laura's going to take that on. But was there any other questions we wanted to ask before on zoning and ordinance administration before we jumped into those case studies? Okay.
So we have a series of case studies we're going to try and walk through. So this experience is I'm going to share some information with you, and you don't get anything the week ahead of time to review. What we will be working with Alex on is setting up staff reports and how that information goes out. So you'll have a consistent permit application, you'll have a consistent staff report for the things that you're going to be looking at, so that you have information to consider before the meeting and refer to at the meeting. But we're gonna try and walk our way through some of these case studies to give you a sense of what are some of the things you might see. So the first one is a special exception. And let me just say, these are cases that I worked on in Jackson County. So the regulations are I'm not expecting you to have memorized the Delaware County regulations or anything. These are just to give you a sense of what's it like to go through one of these. So there's a special exception that's come in. Alex has processed it. It's for a 100-foot tower and wind turbine. So information that would be provided for the Board of Adjustment for this case would be some information about the property. There'd be a map like this, a vicinity map to show where it's going to be located, because this is the same map that can be used on the notices that go out to the surrounding property owners. In this case, the property is about 35 acres, but there's a road that goes right through it. It's called 254th Street. All of the property is zoned A1 agricultural. The portion that's north of that street is about 10.6 acres. That's the project site for the tower and the wind turbine. On that part of the property, is the farm. There's an existing farm operation, including a single-family dwelling, detached garage, bin, a couple of silos, some utility buildings. The rest of the acreage of this property is south of 254th Street, and it's in row crops. The surrounding uses within, in this case, we got half a mile in Jackson County. Usually we do 500, but for towers, we go out half a mile. So within a half a mile, the surrounding uses are residential on the east and west and agricultural on the north and south, but they're all zoned A1 agricultural. So that's the setting for what we, whoops, well, this goes quick. So here's your review standards for Delaware County for this case. The site plan that was provided by the applicant shows you the location of the tower. It's a 100-foot high tower with a 3-foot turbine with 16-foot blades. He's shown where that is. That's that little yellow dot. One of the requirements in Jackson County is however tall that tower is, that's the distance it has to be from a house or a park or a school. The applicant is showing us it's 100 feet from the house, so it's met that requirement. The other numbers are the setbacks, the distances from that tower to the other property lines. And so they're well in excess of any setback requirements. And the reason this is coming in, although it's zoned Ag 1, is because this is not a farm operation. This is a turbine specific use. It is going to be used for this farm, but we're still regulating it. So let's look at the standards for approval. So those were compatibility, transition, traffic, and environmental protection. So would this be compatible with the character of the zoning district and the immediate vicinity? What does anyone think? Or does it interfere with the development and use of adjacent property? Probably not. I mean, this is in largely farmland. However, there are some residential uses. And at this case, there was one neighbor who objected. His house was well over 600 feet from the turbine. Is there a transition or a buffer provided between the proposed buildings or use and the surrounding properties? I think we could say yes. The site plan demonstrates there's several hundred feet from the back, from the rear, and from the front, and 500, almost 600 feet on one side and 700 on the other. Does traffic have adequate ingress and egress? Yeah. People aren't going to be coming from this tower except to service it. So the current access for the farm operation is adequate. And we know this, Alex, because we checked with our county engineer to be sure that there were no concerns. The biggest concern was when this thing comes down the road, making sure there's the proper permit to bring it. Once it's set up, it's not going to impact the road. And then the last item is environmental protection. So the applicant was the installer of the turbine, and he was able to respond to all of the issues raised by the neighbor at the hearing. He could address his concerns about sound and what happens during high winds. These blades will turn and they'll make a lot more noise than they usually do. He had information about the typical operating level of noise. He was a really good applicant because he was able to respond largely to the objections and concerns of the neighbor rather than the zoning board of adjustment. How many of them were turbine installers? None. So this is one of the things that's very helpful. If the applicant really needs to be able to explain and respond to concerns, and then in this case, they were able to do that. And this turbine was approved. Yes.
Just a quick question. On the word excessive, is it how, that's kind of arbitrary. At least what's excessive to you might not be excessive to me. So is there a standard or is there
Yes.
different areas?
So he knew what his decibel, the sound of it was a certain distance away. He also could compare that to other things you might hear, a lawnmower, a farm tractor.
I just didn't know if there was, like, we talk excessive dust. What is normal dust compared to excessive dust?
And so there isn't any standard because this is just one kind of special exception. There could be all kinds that would come through. And so
because the one always gets me is excessive odor. You know, I grew up on a farm, so hog smell doesn't bother me. But most people from town or driving by, that offends them. So what's excessive to me might not be excessive to somebody else. Yeah. So what's the standard?
So some of the things that that can be brought up, someone usually can determine whether that's just an emotional response or there's some facts that go with it. We have some cases coming up where we're actually going to see, I think I have one in here where there are some things. The reason there's terms in there, excessive, if it was something that's a normal day-to-day operation of a farm where livestock are raised, then it's not excessive. It's normal. But it does give us a little bit of, it gives the board a little bit of flexibility. But
everyone trying to move from town to the country, he built the house. Cats. Oh, my dad going to quiet. That's been going on since the beginning of time.
Yeah, exactly.
You know, unfortunately, but again, that's what wasn't normal to him was normal to us.
Exactly.
What's excessive? You know, that's.
You have a nice guide on your website, Guide to Rural Living in Delaware County. Similar one Jackson County has that lets people who move from a more urban environment understand that this is not the same as where you were living. Farmers will be out in their fields with tractors, with lights on all night long. Why? Because they have to harvest the grain. This is one of the things that happens. It's not excessive, it's normal. And so
I get it, but you know, it's just the next person. That's excessive.
And so yeah, so some of these will be that I think I used the word last time, trust but verify. I've heard in my 30 years working with the city of Dubuque, I have had people protest absolutely everything. Some of the kickers were, we don't want that assisted living facility down the road from us because the ambulances wake us up when they come to get the people. Okay, thanks for your input. On to the next one. So the next one is a little bit, oh, I'm sorry.
I have a question.
Yeah.
We have some guidelines on non-commercial towers.
Okay.
Does this policy here coincide with the regulations we have on our non-commercial wind towers?
I don't know, because it's from Jackson County.
Okay.
It doesn't matter.
Okay.
What we do is we look in our Delaware County ordinance. I'm just using these examples because these were ones I could talk about and know what the outcome was. But they are not specific for Delaware County. I didn't change them to match your ordinance. I wanted to give you a sense of the flavor of what it's going to be like. But the thing to do is always look at the definitions, look at your ordinance. even after 30 years, I would still be looking at the ordinance in Dubuque to make sure I remembered it, because we changed it over time.
But the wind ordinance can be more restrictive than your zoning ordinance.
Absolutely.
So you have specific requirements within that wind ordinance that are going to far outweigh the minimal requirements that may be in the zoning.
Right. Jackson County doesn't have one. What I showed you is what they have. But you have a separate ordinance for that. So that's what Dan was talking about. Just because you got the right zoning and you got through the zoning board of adjustment didn't mean you got a clean sweep through everything else. Another good example that Dan mentioned is a floodplain ordinance. If the floodplain ordinance says you can't build there, it doesn't matter if you met the setback. It doesn't matter if it's a really cute house. If it's in the floodplain and it can't be there, you can't build it there. Even if it's the right zoning, that doesn't mean you get to waive everything else and just do what you want.
I just want to clarify.
That's a great question, because that you have more ordinances, more specialized ordinances that we haven't talked about that will play into your zoning. Yep. And Alex already deals with a couple of them, wells and septic systems. It's a good idea to have that before you finish the house. Right?
We have a few.
Yeah, although it happens, right? Okay, here's one where this one is, this is a mobile home in an area called Leisure Lake. Their proposal was that they would get a variance to their front yard setback, 27 feet at the narrowest pinch point, where we require 30 feet. The site is a little over half acre. It's in an R1, which for Jackson County is any kind of residential. But you can see this lot is in a regular shape. The eastern 1/3 is only 0.17 acres. And located on that smaller eastern portion is the mobile home. It has a covered wood deck that would be removed, and that's where the addition would go. This property is served by a private well. It's located on the western portion, and it's also on a community septic system. And the surrounding uses are all residential. They're all zoned R1. So what the applicants are proposing is to give themselves some more room in their mobile home. They don't have a lot of options to do that, except to go towards the street. Why? Well, the well pit is near one corner of the house, and the grinder pump for the community septic system is located on the eastern portion, pretty close to the house. And so they need to stay away from those. And so they're asking to go in the front. If you look at how their lot is laid out, it's following a curve. And so they have 41 feet at one end of their mobile home, but they're down to 27 feet at that pinch point. So this actually, we could actually do this as a special exception, but I've used the variance requirements here just so we kind of go through this. Are there some special conditions and circumstances? Yeah. This lot is not a regular shape, and there's some utilities in the way of doing much in the rear yard. If we interpreted the ordinance literally, would it deprive the applicant of rights commonly enjoyed by other properties? It might. Well, most other properties can build onto their property. Are there special conditions and circumstances to the action of the applicant? No. This mobile home is circa 1960s. They bought the lot just a few years ago with that mobile home, so nothing that occurred has anything to do with them. Would they get any special privilege because they get to enlarge their home? No. Like I said, most of the other properties, that can be done. Will the variance be in harmony with the general purpose and intent of this ordinance? This is a residential district. They want to expand a residence. Would it cause any harm to the neighborhood or the public welfare? No, everything's still on their lot. It's a little bit closer to the road, but if the county engineer feels 27 feet is not a problem, then that's good for the board to know. So in this case, this one was approved. If we put that unnecessary hardship test, it might be difficult because they actually are living there in a mobile home on the property. So this is why we would have, now that I think about it, I would have had this applicant go into the special exception category, where it was only a practical difficulty.
And all the decisions of the Board of Adjustment make no changes to the zoning ordinance.
No.
They are specific to the request.
Yes.
And they're final, unless they're appealed to district court.
Yes, and even then they can prevail, and often do, because in order to lose in court, the board has to be proven arbitrary and capricious. If the board has applied the standards and followed due process, it's very likely they'll prevail. Not always, but pretty much. You follow the process. So here's one for the zoning commission. We had an applicant who wanted to zone from agricultural to commercial. In this case, C1 would be your C2. There's just one commercial zone in Jackson County, and it reads like your C2. So they've requested rezoning, and this is their application quote. A1 will not fit the intended use of the property. The applicant wanted to construct a rental storage garage. And what we also discussed with the zoning commission is that's not why he is rezoning. He's rezoning it just for that, but we need to look at it. There's how many uses are there in C1, or in your case in C2? There might be a dozen or more. Any of those can go in once the property is rezoned. So the C1 district is intended to provide areas for commercial development which primarily serve the traveling public or require access to a major street or highway. Same thing as your C2, okay? There are 2 parcels along the north side of 362nd Street, west of its intersection with a highway, US 52 in this case, and it's about half a mile south of the Bellevue city limits. It's currently in agricultural use. Surrounding it are residential, that's the yellow area you see. Agricultural, the state park, Bellevue State Park is to the north, the railroad line, and the Mississippi River. So the standards for review for the C1, for rezoning this to C1, I don't know where my title came from, but sorry about that. Is the current district valid? Probably. It's being used for agricultural. It's zoned A1. Is there a need for additional land zone for the purpose requested? Yes. In Jackson County, A1 is a holding zone, like we've proposed here, unless there's development that can be shown to be consistent or in accordance with the comprehensive plan. So the case being made by this person is we're within half a mile of the city of Bellevue. We have a demand for this commercial use, and so we want to put it there. Is the proposed use consistent with the comprehensive plan? And you look at the three categories there. Would it result in population density or development demand for services and utilities in excess of the planned capacity? No. It's a commercial area along a highway. There are no services. So whatever is developed there will need to have its own services, and that's where the water and sanitation department will come in. Would it generate traffic in excess of existing or planned capacity? Probably not. It's on a paved county road that intersects with the US highway. Does the applicant intend to develop the property? diligently and within a reasonable time? Yes. The other thing we did with this case is Dan and I happened to have helped the city of Bellevue update their comprehensive plan. And this site is in one of their proposed growth areas. So we sent the application to the city administrator and asked for their comments on whether this use was consistent with their comprehensive plan, and they said it was. And they supported the change. The map I've used here, I don't know if you can pull this kind of map up. In Jackson County, we don't have a land use map to work from. So what I'm using here is how the parcels are classified for tax assessment purposes. So you get kind of an idea of the land use. Because that's something I like to have zoning commissions look at, as well as what is the zoning, but also what's the land use there currently. And so that one was approved. The last case is actually one that Alex is expecting to come through. So this is a new house in the Lake Delhi district. So I wanted to go through the same information we did for R1 when Dan was speaking with you. So this is a specialized district. So we have, for minimum lot area and lot width, we've looked at permanent and seasonal single family units. They need to have at least half an acre, and it needs to be above the ordinary high water line. The lot width needs to be 60 feet. We also have a caveat: lawful uses, lots, and structures in existence prior to adoption or amendment of this ordinance shall be regulated by the section on nonconformities. Nonconformities are your ordinance allows them to continue, be maintained and repaired until they're changed into something that goes into compliance. The minimum required front side and rear yards, we would look here just under the category for dwellings, because the proposal is a new house, and accessory buildings. So we would be applying the 15 feet for front and rear, 5 feet for the side, and 25 feet from the ordinary high water mark, lakeside. And then the height we're looking at is 2.5 stories or 35 feet. This property doesn't meet the standards of R4. The project is then going to come in under your special exception uses and structures because of that opportunity Dan mentioned. It's the ability of the Board of Adjustment to approve modifications to those bulk standards if they're no more than 50% of the requirement, provided that the county engineer and the county sanitarian are also okay with them. So here's the project that Alex is going to be looking at. It's the property with the outline in blue. It's about just a little over 16,000 square feet. Unfortunately, almost half of that is in the water. So they really only have 8,800, a little bit over 8,800 square feet of land to work with. There's also the street that goes through. 208th Avenue splits the lot. So the house itself is on 5,227 square feet. So it's not conforming due to lot area. There currently is a small seasonal cabin, 880 square feet. The property owners would like to replace it with a 1,259 square foot year-round home. And they want to take advantage of that 50% reduction of the required setbacks. So they want to go from 15 to 7.5 in the front. And the sides, they want to go from 5 to 2.5. And lakeside, they want to go from 25 to 12. They are able to provide off-street parking. They'd be required to provide 2, and they can actually provide 3 spaces. And that would be across the street on the portion of their lot. It's on the other side of 208th Street. They would excavate and put in a retaining wall to create that parking. This site is served by a public well. And the applicants have been made aware an alternative septic system is going to be needed because of the small lot size. So this lot and everything around it are residential, and they're all zoned R4 effective on January 1st. Let's see. Did you want to add anything before I keep going?
No, I think the next slide.
Next slide probably has what you need, right? Okay, good. All right. So the argument the owner's making is most of the cabins are built right up to the roadway, like the current cabin that he's bought. He believes that if he builds a very small house that adheres to all of the setbacks in the center of his lot, that it won't conform to the general look of all the neighbors. Anything else?
No, I said it's a couple that bought a house, or it was a cabin at the time, just seasonal, a few years ago. Him and his wife had retired. They sold their place down there. They're living in this current seasonal cabin over the winter. And they had intended in the spring to tear down the house and build new. And he came in, he said, hey, I seen there's zoning. I know I won't be able to make the required setbacks. So I'm gonna try to get the special exception, which I pushed him towards instead of issuing a variance. And then he said, well, he said, I could build a house in there with the required setbacks. But he said, I could go up with it to accommodate, to get to the square footage we want. But he said, as an aging couple, we don't want to be going up and down stairs all the time. So he said, like, build a ranch style house. He said, I don't want to build right up 2 property lines, and would be fine going with the special exception. But he said, I just don't feel that what I would build would look quite right with everything else being put right up to your roadway. And it wouldn't conform to the general. He said my house would be the most in compliance out of any of the houses on this lot here.
Okay, thanks. That's really good background. So that's the kind of information that Alex can gather from the applicant, and the applicant can also bring forward in their application and in their presentation to the board. So if we look at the review standards for approval, I think the applicant did a pretty good job reading the ordinance and trying to work with Alex to present a case that would meet these standards. Is there compatibility with the character of the district in the immediate vicinity? He's trying to make the case that there would be if he's allowed to build his single-story home. And because it's similar to how other properties are built, it doesn't seem like it would interfere with their use and enjoyment of adjacent properties. Is there a transition or a buffer provided? Yes, he's got setbacks, and he's meeting that 50% reduction for the special exception. Does traffic have adequate access? Yes. He's got a street that goes through his property. He would be able to access his parking area off of it and his home. So if there was a need for emergency vehicles or other types of services, they can reach his property. Environmental protection. Is he planning to undertake the necessary requirements to safeguard the environment? Yes, because he's going to get an alternative septic system that meets the codes that Alex would require, so that the lake and the groundwater are not impacted. And there really isn't going to be any of those other considerations of noise or dust or anything like that, because it's a single family home. So one of the things the Board of Adjustment might look at in this case is, even though they're required to have a special alternative septic system, the board could make it a condition that the necessary permits for that system and the system's installation occur concurrent with the house, or whatever's the right time frame. Maybe it's before the house. Alex was telling us about some that It was kind of squeezed in after the house is in. But that would be a reasonable condition for the board to add on to make sure things happened in accordance with these standards for approval. Does anyone have any questions on this one?
Alex, on that one, are they talking to the people up in the hillside? Because the people on the hillside want to do something to keep it from eroding.
Oh, okay.
And they'd like to work with the people down below so they could come at the top part or.
That I do not know. I know I had talked with the property owner that approached me. He said he was planning on carving out and putting in retaining wall there, so at least it would help on downslope side. For you want to have parking for up to 3 people.
Because you know, when going up there, the water is eroding so bad and it's coming down, I'm sure. And so they need to work on the above part with the people above to help them so they can, because cutting that hillside is not a simple thing.
No, and that's what he had said. He said he was a general contractor, and he had said he had planned on setting large rectangular.
The block, but
Yeah.
a lot of them, the bad part is a lot of them are not back. I mean, not putting rock and something behind it to really.
Sure. Allows for that.
The lady mentioned.
What's that?
I see too many of those retaining walls.
We're
They're
under.
like this, but they're like this now. And it's like even at the outside.
Almost at the end there.
And I know
Didn't
more people putting up the same
It's
thing.
just red one storage
Sure, as
space.
long as they do something. I think the first one is just that, which is a coach from
Could this be?
Brandon Eckert. But he put the stuff in behind, he did it well.
Sure.
Yeah, I could bring that one in.
There's not an
Yeah,
ordinance.
we could bring that one in. Sure, that's
I
okay.
think this would be,
And
this
Absolutely.
would help with
challenge
that.
and separate that out, because it meets all standards. If it gets the special
And it's
exception,
not a platted road.
that is true, so.
Yeah.
But as far as meeting standards, having to work with neighbors, I mean, there really isn't anything.
I guess I need to talk to them because the neighbors want to work with the people below, so they don't.
Have that become an issue, and I mean, I think everybody would be on the same side. You want to prevent erosion,
Right.
I mean, there's no guarantee. Unfortunately.
And that's a good idea. We often recommend the applicant speak to the people who are going to be notified, and we'll send them that list ahead of time and encourage them to contact those folks so that the first thing they find out isn't something in the mail from the zoning ordinance. It's something from the person who wants to do the project. Oh, and then here comes that notice. Oh yeah, I talked to these folks.
Well, the people
So
that
we're
are
gonna
gonna
encourage.
do it up above, are they gonna be required to? They don't have to apply, or they don't have to,
No, they would get a notification. So what I would suggest is the owner of the property in blue, talk to the owners of the property above them, because they're gonna get a notice. They're within 500 feet, and that may spark the conversation that you're suggesting.
right, because the ones that are going to start trying to modify, they don't have to apply for any permit or anything to.
We just landscape.
Landscaping.
Yeah, so I don't.
How big an area are they landscaping? Is it over an acre?
They just bought additional, so they could do that.
If it's over an acre, do they have to get a permit from the Iowa Department of Natural Resources? Do you have a watershed management authority in Delaware County?
You tell me.
No, okay. You have a soil and conservation service though.
But that's more of the place down below.
Ours, I understand. I don't know exactly.
I would, I'll see what I can find. and send it to you, because if they are gonna be dealing with over an acre, they might need a permit.
There's about 3 farmers up above that bought up above in the hillside, so they can prevent it from coming down on their house.
Okay. If it's a farm operation, then
Not farmers, I mean.
They're not farming it.
They're not farming it. Gotcha. Okay.
They have seasonal.
Gotcha. Okay. Because there are programs that can help farmers with erosion. And so that was the other thing that I was thinking about, but
They're just, they bought property so they see what's coming down their hill.
gotcha.
And it's gonna come on their
Okay.
face if they don't.
Okay. All right. I'll see what I can find and send. We also had a suggestion from Carla to talk about the amendment that's coming. We already have an amendment before it's in effect, but it's a good one. It's a good one. Do you want me to talk about it? Or do you want to talk about it?
I can start with you.
Sure.
So there's a lot of already developed areas in the county. The Lake Delaware district, and then your R1 district, which is unincorporated communities like Petersburg, Sand Springs, Oneida, and then places like Jefferson Road along Bailey's Ford or Honey Creek Road going north out of Manchester, some subdivisions out in the county as well. And so the county hasn't been giving, there's no oversight from the county as far as where they can build, whatnot. And so places like this, to make it conform to the ordinance, it would be very challenging in a lot of cases. And so the city of Manchester, they have in their zoning ordinance, it talks about average setbacks. So in places like that, anything new has to adhere to the ordinance, or they have to seek a special exception or variance. But your already existing places, like down here, for example, everybody's built right up to the roadway. And say it's between 5 and 10 foot off the road is your houses. So you could modify it without having to go to Board of Adjustment for a special exception or a variance if they build it no closer than 7.5 foot, your average of the 5 and the 10 foot, within 500 foot along any roadway. And it's also subject to public safety as far as being able to get emergency vehicles up and down, and doesn't cause any additional impact to other properties on that. Because otherwise we're going to have a ton of people coming in for special exceptions like what I presented to you here. Otherwise, it's going to be continuous people coming in, especially like Delhi district. And then your R1 district could potentially have some impact there as well. But this allows it to work within the ordinance because, again, they didn't have any oversight for a long period of time, and now it kind of prevents issue with it.
Right. So the purpose of our zoning ordinance wasn't to make life terrible for people in the Lake Delhi region. So if we can explore amendments like this that's coming up before it goes into place, but also in the future, what we're doing is we're making an ordinance that reflects the existing development. It's and it's development, it's quality development. People are living or vacationing in these homes. There's recreational and commercial uses that they get to enjoy. So this is a development that we want to see continue and be able to exist. And the fewer times we are forced with something that's non-conforming, the better. And so we even wrote this amendment, I think, for both the front and the rear yards. And let's look at both sides of the street. So we're trying to be as comprehensive as possible in a development like this. Now you're running out of power. So that is the type of thing that we would try to do to make the ordinance work as much as possible and as often as possible at the administrator's level. We don't want to send people to the Board of Adjustment. We don't want to send people to the Zoning Commission unless we need to. So having these kinds of adaptations to reflect existing development is a really great tool. And I'm sorry we didn't think of it sooner. I'm glad we thought of it in time to help these kinds of cases. Sure.
Because they're becoming more prevalent in the area. And when you were saying about traffic control, if it's out in the county, out in the country, and there are houses near, I mean, like across the street or whatever, they could oppose because saying there's going to be more volume of traffic coming in there. Would that present an issue?
They could. We would use information from what's called the Institute of Traffic Engineers, and they have, and I think they have information about what the traffic generation is from certain types of uses. You can also get information from either your county engineer and or the Iowa Department of Transportation potentially on what are the traffic counts. But it would take more, something more like the Field of Dreams than a single apartment building to impact the roadway. I mean, I don't see one. I mean, people can make that argument, but the statistics from a reliable resource like the Institute for Traffic Engineers would refute those claims. So that kind of goes back to that other case with the excessive noise. The applicant for that tower in the wind turbine had the facts, could address the concerns, and was able to provide examples similar to your example of weaning calves. This is what a turbine generally sounds like. It's not even as loud at your property line as the lawnmower you're pushing. So this gives us a perspective. Another case we had was people said that's going to impact my property value, and you will hear that, I'm sure. To make their case, they had information from realtors, but even better from appraisers who provided an opinion in writing as to that. Yes, indeed, a salvage yard would impact the residential property values. Now you can get up and say that,